It's definitely scary. I mean, I think of it
Well,
like
this Oliver Stone is a little not hooked up right.
he's all of the words, the adjectives that you just described of the movie.
Yeah.
And when we were making the movie, we were trying to think of something to get the crew, because they needed something nice after working with him for that long. You know,
those life
it's
experiences.
kind of fun. Yeah.
Let's show the folks.
I survived Oliver Stone shirts for the crew.
Oh, you had I survived Oliver. Oh, how did he
Because,
like that? He didn't care that.
I don't think so.
Hi friends, it's Katie. Welcome back to my channel. It was a week ago that Blake Lively and Justin Baldoni's lawyers were in the court arguing over the need of a protective order. And in my video that we talked about last week, my prediction was that the judge's decision would include a modified version of the one that Blake Lively proposed based on how the oral arguments went, and that he would designate certain portions of discovery as attorney's eyes only. I also stated that I believed they would not get the entirety of the protective order that they sought. I mentioned that the judge was particularly not impressed with some of the language that they were using. He described some portions of it as overbroad and was specifically annoyed by language about high-profile people, and that he would not at all in any capacity close the court in any way, shape, or form, no matter what they said. Or would he allow redacted things to be filed to the court without approval prior to filing, and that anything that comes into the court would become public? So as I predicted, that's exactly what the order became. So you're going to see things on both sides today. You'll say Justin wins or Blake wins. I think this was expected probably on both sides. I think Justin's probably would have preferred to not have to do any of the attorney's eyes only. But the truth is that this protective order is actually not a bad idea because it protects both sides. And the judge saw it more than we're just going to protect Blake. It's more like we're going to protect both sides. Both sides have used this lawsuit to make publicity in the press. So the order was signed earlier this morning. And in a video yesterday, some of you had said to me, Katie, I can read everything myself. I don't need you to read me the whole document. So I am going to spare you that I read you the whole document. I'm just going to read you portions that I think you'll find particularly interesting here. The judge signed an order today, and he denied it in part and he granted it in part. Like I was saying earlier, some parts of it he felt were overbroad. He also modified language in it. So it's not necessarily a full win. And I don't disagree with this order. I think it's good for both sides. One of the biggest issues for him was sort of navigating the right to privacy for non-parties of the suit that might be brought in unnecessarily, and whether or not the information they provide will be used against them by the other publicists that are involved in this case. And the issue for the judge specifically wasn't necessarily that Justin's going to use information or that Blake's going to use information, but rather the fact that there's publicists and managers and people on both sides that work specifically with having a relationship with the press, and knowing that they have such close access to the press, there was a need for a protective order for that reason. So this is sort of how he came to his decision. It says, each of the Lively and Wayfair parties have filed claims against the other. Jones, the owner of a public relations company, has filed claims against her former employee. The parties have leveled accusations of theft of trade secrets and the disclosure of confidential, sensitive information against one another. Discovery will inevitably involve some amount of sensitive business and personal information that premature public disclosure of which could cause harm to the producing party or to a third party. So when I saw that, I was like, okay, so Blake has been in the court playing the victim. And obviously she's claiming to be a victim, but she was very dramatic in her arguments last week. The attorney was, that her safety was in peril, and that, they're so dangerous and there's dead bodies. And a quote that she attributed to one of Baldoni's business partners, Steve Sarowitz. And here, the judge is like unmoved by that because he's saying that both sides have leveled accusations. So it's not just that Blake is a victim, but also Baldoni and Wayfair and the associated parties on that side are claiming to be victims. So you have two sides claiming to be victim, and it's right now only allegations in court. Nothing yet has been proven. So he's basically giving that an even playing field, and he's not taking any more weight into one or the other. And he's just saying that because both sides have made these accusations and both sides are engaging in it, this is going to be best for everyone, especially for non-affiliated or third parties that aren't actually being sued but could be brought into the situation. So what he's going to do then is he's going to limit what will be actually AEO. And he referenced that the moving parties argue that an AEO provision is appropriate because of the risk that sensitive details revealed in discovery will become weaponized by the parties in the media, chilling third parties from producing discovery and imposing an impermissible tax on the prosecution and defense of legal claims. The moving parties specifically note that potential harm to third parties who could have private and sensitive information spread through the press as a byproduct of this litigation. And then the Wayfarers responded that Lively has already disclosed sensitive personal information related to the alleged harassment, and they suggest that there's no need to presumptively designate material AEO at this time, and any need for material to be designated AEO could be determined as it rises. He says that the moving parties have shown good faith that this was a good reason because it's critical right now so that the case can move forward, that they at least do this, because if they don't do this, it could unnecessarily slow things down. And it's more important to him that this goes quickly than it goes slowly, right? So he wants to make it so people won't be scared to give information and will participate in discovery. It's kind of like being the mediator here. So it says, in particular, the disclosure to the parties of certain information that will invariably be exchanged during discovery, but which may not necessarily be to the prosecution and defense of this case, presents an incremental risk of annoyance, embarrassment, and oppression that cannot be effectively controlled by the court's model. And I think their biggest issue is that his current model has this provision where they have to sign a document that says they're not going to violate a court order. And then if they do, then they can go to contempt. But he doesn't know that that would actually work in this case, because if someone wanted to violate and leak it to the press, like one of the publicists, it would take so long for sanctions to actually be issued to that party. And by the time that came, the damage would already be done to the person or the third party that had that information disclosed. So another aspect of this AEO is that they're business competitors and both sides. So when they look at the model protective order, he believes it's not totally sufficient because both cases on each side have businesses that are competitors, and then there's actually allegations of sexual harassment. And because of that, there's a significant risk that disclosure of this information could be great. So like, think of it as this: Stephanie Jones is a competing publicist to Melissa Nathan. Jen is a competitor to Leslie Sloan. So you have two publicists over on one side, you've got Melissa Nathan and Jen Abel on another side, and each of them have access to the press. And that's his biggest concern. It has nothing to do here that Justin is going to leak any of this information. It's not that it's dangerous for Justin to have this, but it's more like we need to keep this out of the hands of the publicists. So it says several individuals and corporations on each side of this are in the business of public relations or media and have access to the press. The details of this case have been closely followed in the media, and each side has accused the other of litigating the case in the media. And where confidential information is not disclosed to the media, it may spread by gossip and innuendo in those in the tight artistic community in a position to do harm to one or the other of the parties, but in a manner that might not be readily or immediately detected. So what his concern is it has nothing to do with Blake. It has nothing to do with Justin. It has to do with the PR people. And that not only could they go to the press, but they could also be in social situations and they could start spreading gossip about Justin to competitors or to studios. And equally on Justin's side, Jen and Melissa could do the same. And in that respect, when you look at it just from a public relations perspective, I don't think this is a bad idea for either side. I think I said a couple days ago that it almost feels like the public PR people are the whole reason they're in this mess to begin with. The PR people created a quote unquote shitstorm. So what he's going to do is he's going to limit the amount of what information can be designated as confidential. Okay. And so when it comes to trade secret information, they're going to have to disclose all business and marketing plans for It Ends With Us to the other competitor. So both sides. So both sides will be having to share, and there's no AEO for that, period. But if it has nothing to do with It Ends With Us, that's what they can mark as AEO. So if Jen and Melissa want to see what Leslie's PR strategy was for Blake for It Ends With Us, they'll get it and they'll get to see it. But they don't get to see what Leslie's doing for someone else or for for a project or for someone else. Okay. So he's not going to limit anything to do with the film. Medical records obviously will be marked AEO, but that's going to be done for a different reason. When it comes to medical information, he is saying that it will be marked AEO, but it may become necessary for information to become disclosed to a party at some stage, depending on what the contents are. And given the accusations the parties have made against one another, the challenges that the court would have in enforcing a protective order against persons other than the lawyers, it's appropriate. So they'll initially designate medical information as AEO, but if it comes up later that it needs to become less confidential, or if it's going to become testimony, or if it's going to become part of the case, then it will no longer be AEO. They're not allowed to, see security measures. So they don't get to see what the personal security detail is of Blake. And Wayfair has already said they don't care about that. And then highly personal and intimate information about third parties. So he says, Lively has asserted claims for damages in the form of emotional distress. Some information of a personal and intimate nature regarding the parties will inevitably have to be shared with persons other than the attorneys. The parties are making the accusations who are the subject of the accusations. And it says, and the parties who are making the accusations or who are the subject of the accusations have a right to participate in the prosecution and defense of the claims. The attorneys have a need to consult with their clients. At the same time, it is in the nature of the discovery that the net will cast wide and that each side will be forced to disclose to the other information of a sensitive and personal and intimate nature that is not necessary or even relevant to the prosecution or defense of the claims. The point is even more apparent with respect to non-parties. These persons have not signed up for this lawsuit, but by the virtue of Rule 45 subpoena power, they will inevitably be brought into it. Their personal information, which may be contained in the documents to discover, may well be the least centrally relevant to the determination of the action, blah, 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 blah. So basically, they're going to give an AEO designation to non-parties, third parties, and then it says before the parties make an AEO designation, the protective order places them the burden of determining that the information is not directly relevant to an allegation in the pleading. So if, say, they want Hugh Jackman's text messages or something, he would be able to, if he has texts that don't include stuff about It Ends With Us, that's the kind of stuff that would be not relevant. But if it has anything to do with this case, that would not be considered attorney's eyes only. It's basically stuff that's going on in his life that has nothing to do with this situation. Same with Taylor Swift. So we're not going to say find out if Taylor and Travis's relationship is staged and fake. That's what I'm just saying. So he changed some of the designations. He said some of it was just like way too broad language, like Likely to cause competitive business, commercial, financial, or privacy injury is too broad for him. So he's going to say likely to cause a commercial or privacy injury. They've narrowed it down to be stated that it may be marked only if it's highly likely to cause significant business, commercial, financial, or privacy injury. So it's not going to be as easy for them to get this. So at the end of the day, he's denied in part and he's approved in part. And then just to get the meat of it, here's the categories. He's trade secrets, confidential business plans, marketing plans, strategies for clients other than the parties in this litigation, confidential business projects or leads on projects for clients other than the parties in this litigation, confidential creative projects or ideas other than those involved in this litigation, security measures taken by parties or third parties, medical information of parties or third parties, and highly personal and intimate information about third parties and highly personal and intimate information about parties other than directly relevant to the truth or falsity of any allegations in this complaints in this case. So Blake and Ryan can only claim AEO for stuff that has nothing to do with the case. If they had conversations about Justin or the film, that has to go forward. They only get AEO for stuff not directly. And the same thing goes for the third parties. So it's going to protect their personal secrets that are going on in their lives that have nothing to do with the film. So we're not going to get as much tea, I guess, is what, some people were hoping. We were going to get all kinds of tea in here. And there's enough tea in the allegations in the case to begin with. There's a lot in here that really most of you won't even care about because some of this we'll never even see. If it settles, we're not going to see any discovery anyway. And if it goes to trial, we're only going to see what's produced at trial. We're not going to see all the discovery anyway. That's what discovery is used. And if you've gone through a lawsuit, complaints can say a lot that may or may not be true. And I've been on the receiving end of really awful complaints that have made such vicious allegations against me that weren't true and cases were dismissed. So I always have to remind myself when reading either party's complaint that not all of this is actually going to be based in fact. And when things are done under information and belief, it truly means they don't necessarily have the evidence to prove what they believe this to be. And what discovery is going to allow them to do is get the evidence that they need to prove these claims at trial. Okay, so at the starting point, each one of them believes that they have grounds for these claims. All right. But at the end point, they have to prove it. And that's what discovery does. So that allows people to get interviewed for depositions. It allows documents to be reviewed, and it helps both sides build their cases. But also, discovery can help disprove the allegations. So say they start going through the discovery and they realize, well, Leslie Sloan wasn't as involved as we thought. Or they realize Melissa, Nathan, and Jen Abel didn't do what we thought they did. Or they start looking at the communications and they realize that this all got blown up out of proportion on both sides. And that happens a lot. And that's why cases settle, because it comes to a point where it's like, this isn't benefiting me, this isn't benefiting you. And then you come to an agreement. And settlements do not have to include money, by the way. Now, Justin's lawyer states that they're not interested in settling. He's interested in proving his innocence. And so from my perspective, the only way he's going to win is if they go to trial and they're able to prove that this didn't happen, or if they can go through discovery and through the discovery process, they can disprove literally all of her claims, which think of it like this. There's a process called a summary judgment. And I just filed one in the case that I've been involved in for 3 years. It means you've gone through all parts of the discovery, and through the discovery process, you've determined that the other side doesn't have the evidence that they need to win. And that for that reason, it should be discharged. And the summary judgment goes through like point by point on what is lacking in this person's discovery and what you found and why it won't be reasonable to go to trial. And then it can get discharged that way. Summary judgment is often used when a motion to dismiss fails, and it goes to that place after the exchange of discovery. I honestly wouldn't be surprised if either side we're able to get this out via summary judgment. And then if it goes to trial, it'll be up to a judge or a jury to deciding on how they do it. But when it comes to anything that is filed in the court, he was very specific about that. He says all persons seeking to file redacted documents or documents under seal with the court have to follow a rule of practices in the civil cases. No person may file with the court redacted documents or documents under seal without first seeking leave to file such papers. All persons producing confidential discovery material are deemed to be on notice that the Second Circuit puts limitations on the documents or information that may be filed in a redacted form or under seal, and that the court retains discretion not to afford confidential treatment to any confidential discovery material submitted to the court or presented in connection with any motion, application, or proceeding that may result in order or decision by the court. So there is no presumption that confidential discovery material will be filed with the court under seal. They have to use their best effort to minimize sealing. So his thing is like, okay, so when we get past discovery and you start filing motions, you can't just file stuff under seal. You have to do a leave to file request, and then you have to argue to me why it needs to be filed under seal. But then he also is basically saying, like, I'm not going to just seal it because it's confidential, because at some point it's going to become public. Any party filing a motion or any other papers with the court under seal shall also have to publicly file a redacted copy of the same via the court's electronic case filing system, and that redacts only the confidential discovery material itself and not the text that in no material way reveals the confidential discovery material. So they're still going to have to submit things to the court, but they can only redact the stuff that's confidential, and that only. And then stuff like their phone numbers, addresses that will is bound by a protective order. If they violate, it's up to contempt of court. And that he made clear in here too that he will not be closing the court like at all. So this is what he said. All persons are hereby placed on notice that the court is unlikely to seal or otherwise afford confidential treatment to any discovery material introduced in evidence at trial, or supporting or refuting any motion for summary judgment, even if such material was previously been sealed or designated as confidential. So he's not going to close the case and close down the court or allow them to seal because at one point it was deemed confidential. Once they get past that time, he's saying, I'm unlikely to seal this. Just to give you sort of a high level, he's allowing them to go through the part of discovery without fear that information from either side will get leaked to the press by the publicists involved. And then once it goes past discovery, at that point, this whole discovery protective order will become at a point in time moot, because the information that's needed to either prove discovery summary judgment or to prove their claims at trial will be needed to be used. And at that point, they lose that designation of confidential. So again, I've had one of these in one of my cases. And like I said, they're a pain in the butt, but they also protect you. So, your information, if you're Justin, then you don't have to worry about like disclosing your own medical information and then like Blake and Ryan or whoever using it to like run to the press, right? So Blake's side released a statement, which of course is acting like they won the lottery. And they said, today, the court rejected the Wayfair's party's objections and entered the protections needed to ensure the free flow of discovery material without any risk of witness intimidation or harm to any individual's security. With this security in place, Ms. Lively will move forward in the discovery process to obtain even more of the evidence that will prove her claims in court. First of all, none of this had to do with witness intimidation. Not one time in this entire order did they address witness intimidation. Not at one time did he address personal security. He never implied that anyone's security was at risk. And he flat out just said, they want this with regard to security. Wayfair says they don't care about security details. So there. And that's the extent of what was issued. So it's a lot of nothing there. It's just them trying to put that narrative out there and act like Blake won, right? And then Brian Friedman told TMZ, we are fully in agreement with the court's decision to provide a narrow scope of protections to categories such as private mental health records and personal security measures that have never been of any interest to us as opposed to Miss Lively's exceedingly overbroad demand for documents for 2.5-year period of time, which the court rightly quashed. So his response is basically like, yeah, they just said that, but we don't really care. And actually, it was Blake that wanted to know who Justin was talking to 2.5 years before the film was released. And he said, we remain focused on the necessary communication that will directly contradict Miss Lively's unfounded accusations. We will oppose any efforts by Miss Lively and her team to hamper our client's ability to defend against their attacks by incorrectly categorizing important information as trade secrets, especially considering there are no issues in providing these communications willingly to the New York Times. So when it comes to Brian Friedman, he was on a podcast today. And my assessment of Brian is that they're really not interested in like the intricacies of these relationships. He just wants to be able to prove or disprove the claims that she's made. And he believes that they will be able to disprove her claims. And really, they won't settle because they want to prove that Justin's innocent and that the Wayfair parties didn't do what she said. So Blake is going to continue to try to ramp this up and act like Wayfair is dangerous. But to be clear, the judge stated that both sides are engaging in this behavior. Both sides have leaked information to the press. Both sides have been accused of claims. Neither side here is coming in victimless. They're co-defendants and co-plaintiffs. And that's what's going to be up to the judge to decide. So Blake can say she's a victim, but she hasn't been issued the court hasn't issued that she's the victim, right? And Justin can say she stole the film and she did all these extortionate things and breached contracts, but Blake hasn't been held liable for any of that yet. So right now it's all just allegations in court. And then finally, something that I was thinking about when it comes to this case is that one of the issues at hand that Brian brought up in a podcast today, it really comes down to each one of them violating their NDAs. Okay. So when they made an agreement about the 17-point thing and the contracts within the film, they all had a non-disparagement agreement. Okay. And Blake's camp wasn't supposed to disparage him, and his camp wasn't supposed to disparage her. And it's that breach of that contract that they're fighting over. And Blake is saying that he breached this contract and it was retaliation because I brought up I was sexually harassed. And Brian is saying, even if people spoke to the press, she has to prove that it was retaliation for her bringing up these issues to them. So if they're talking about creative direction, they're not actually speaking about the sexual harassment, right? If they're talking about the fights in creative direction, that had nothing to do with the sexual harassment. So she would have to claim that talking about film production and the issues in creative have to do with sexual harassment. And that's going to be a very high burden for her to claim. And that could be a technicality in how he also wins too. So that's all I have for now. Obviously, there's been some other filings. We'll get to all of that later. Leslie Sloan just responded with her motion to dismiss. She wants it all thrown out. And there still is some questions to me about his complaint because he did a group pleading, which is not usual. I've not seen that before. And he's assigning every single person to every single claim, which again is not typical in a group pleading. And they haven't sought leave to file an amended complaint from the court either. So let me know what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.